Okay, now I think I've got phones on. Thank you so much to staff who are so helpful with that. I'll call the meeting to order of the Conference Committee, State Government, Finance and Policy and Elections, Veterans and Military Affairs, today being Tuesday, May 11th, 2021. So welcome, everyone. Glad to have you here today. So we are going to be going into some testifiers in regards to the Veterans Restorative Justice portion of our bill today. And so we really appreciate that. And members, we will be giving Mr. Ward, Mr. Else, and Mr. Kemery an opportunity to testify for 2 minutes. And then we will also be having Senator Limmer here today. He is the Senate Judiciary Chair, and he'll be able to be here to talk about some things that are on his mind as well. But I want to encourage you all that this is an opportunity to have a conversation in regards to this. So members, if you have questions after the testifiers present their points, then feel free. Do want to mention that some of these folks have already been in front of the Conference Committee before, so we have heard from them, but nevertheless, today we're focusing on that, so we're glad to have you here. With that, I'm going to go ahead and Chair Nelson, did you have anything else as we get started today?
No, I just hope we have a good conversation and hopefully we're able to resolve this.
Sounds
get it
good.
Moving forward.
Thank you very much. Okay, with that, I will call on Mr. Bill Ward. He's on the testifier list first. So, Mr. Ward, welcome to the Conference Committee. Glad to have you here today. And would you just go ahead and state your name for the audio record and then go ahead and present your testimony.
Thank you, Madam Chair. My name is Bill Ward. I'm the State Public Defender for Minnesota. You said we have 2 minutes. I'm not sure, as fast as I talk, I'm not sure 2 minutes is going to be able to bear out the concerns that I had originally regarding how the veterans were treated in our state. I saw that the Veterans Defense Project sent a letter to this committee which really outlines how this process began and how I got involved. For those of you who do not know, our public defender agency represents clients in all 87 counties in this state. As such, I'm in a unique position to see how our clients are treated in all 87 counties. And nobody likes to admit this, but there is disparate treatment for our clients in the different counties. And one of those areas has been how we treat our returning veterans. As an agency, we saw how the unique concerns that we needed to address with the returning veterans based upon the massive deployments that they were engaged in. And ultimately, we recognized that unique resources needed to be had to help out those individuals. In 2017, the Veterans Defense Project was organized. I was asked to be a part of that project, basically, again, because of my position, but also because I am the person who had taken my staff out of the veterans treatment courts because they were post-adjudication. And with our limited resources, we did not have the ability to represent our clients in post-adjudication because the cases are then closed. I agreed to be a part of this project because, in my belief, no matter where you're arrested, Kuchaching, Knavik, or Carver, a person should be treated the same way if they're suffering from individual issues as a result of being a veteran. We came upon this project with the idea of a unique lens as to how to address our veterans, recognizing that we need to honor their service just as they honored us by serving. Ultimately, this body put together a model that was incorporated from other models throughout the country. And you have that model before you, which is some of the rationale for the angst. And the concern that I've been hearing is if a person is eligible, that they shall be placed or assessed under the statute. And folks have some concerns about that. And the reason I believe that's the appropriate approach is because knowing the counties the way I do, knowing how culture changes glacially, if in fact the shall language about providing the treatment and resources that are necessary is not a part of this model, that it will be a slow change for counties to incorporate this model to actually help and treat our veterans. Mind you, if a person is placed into this process, is allowed to be sentenced pursuant or be put into the process pursuant to statute, if the individual does not follow the conditions of probation or the conditions set out by the court is under no obligation to provide a stay of adjudication at all. And that's clear as part of the statute, the way, or the bill, the way it's drafted. The other concern I've heard is that this is a separation of powers issue. And I've said this before in testifying. It seems to me ironic that when the Senate and House agree to mandatory minimum sentencing and more harsh punishments, they take that discretion away from the courts, that there doesn't seem to be as much of a problem. And I will remind you, everybody here who does not know, that the legislature created 15218, which is a mandatory stay of adjudication for certain drug cases. So again, the reason for the language is so people are treated fairly no matter where you are accused of a crime throughout the state of Minnesota, and that's the basis as to why it was set up the way it was, how it was drafted, and you see the different individuals who were involved in the drafting of the model, and of course the courts were not involved in the drafting of the statute. I know the time is limited, so I'll stand there, Chair.
Thank you, Mr. Ward. You actually did a very good job. Sometimes summarizing makes you focus on the major issues, which can be very helpful to do that. Members, we will have questions after these 4 testifiers, so please go ahead and write down your questions or issues that you may have, and then if these testifiers can continue to be available, we will probably have some questions for you that will help you to delve into this a little bit further. With that, I'll go next to Ryan Else with the Veterans Defense Fund. Mr. Else, would you go ahead and again state your name and organization for the public record, for the audio record, then proceed with your testimony.
Thank you, Chair and committee members. My name is Ryan Else. I'm an attorney with the Minnesota Association of Criminal Defense Lawyers and the Veterans Defense Project. I'm also a veteran who's had to deal with some service-related mental health problems myself. I'm here to urge you in as strong terms as I can to pass the House version of this Veterans Restorative Justice Act, beginning at line 180.4. You've heard a lot about the policy from me in the past, so I'm going to reiterate kind of the process we got here. We had a negotiation over 18 months with stakeholders, from the County Attorneys Association to the Chief Public Defender that you just heard from, and both the state and federal VAs. And the bill is supported by the Minnesota County Attorneys Association, Chief Public Defender, the Minnesota Association of Criminal Defense Lawyers, Violence Free Minnesota and other domestic violence groups, the Minnesota Department of Veterans Affairs, the Minnesota Social Service Association, and all of the chartered veteran service organizations. The House version is supported by these groups because it's good for public safety to use legal incentives to ensure rehabilitation of our combat veterans whose skills pose a unique threat when they turn criminal. The House version has also benefited from the refinement through the work with Senate Counsel Mr. Backus. The Senate version, on the other hand, is not supported by any of these stakeholders or any other stakeholders that I know of. It is not the product of careful policy development. By excluding crimes of violence and domestic assaults, it fails to reach those veterans who most need rehabilitation because they both pose a violent threat to public safety. This would be a large step backward from the veterans courts that currently allow stays of adjudication on crimes of violence and domestic assaults. Years of hard work went into this. There is a reason why such a wide breadth of people, including those who are charged with public safety, like the County Attorneys Association, support this. And I really hope, especially the crimes of violence prohibition that's in the Senate version, is not passed into law. Thank you.
Thank you very much, Mr. Else. Appreciate your comments. I trust you can stick around so that if we have questions, we can follow up with you.
Yes, Madam Chair.
All right, thank you very much. Next, I'll go to Todd Kemery. Mr. Kemery, for the audio record, please state your name and organization, and then proceed with your testimony. Mr. Kemery is not online, staff, are you? He's on, okay. Mr. Kemery has logged on. Our understanding was he needed to be on the agenda early because he had other commitments. I think we had somebody, Mr. Kemery will call for you again to have an opportunity. Okay. What was the name of the possible? Oh, Tommy Johnson. If Tommy Johnson is online, if Mr. Kemery is unable to speak right now, Mr. Johnson, you can go ahead.
Thank you, Madam Chair. Thank you, committee members. I'm representing Commander's Task Force in the absence of the Commander's Task Force Chair Todd Kemery. The Commander's Task Force is made up of 9 congressionally chartered veteran service organizations, from the American Legion to the DAV, to the Vietnam veterans and veterans of foreign wars. We have been following this bill since the working group started on it, because each of the organizations in the Commander's Task Force has a national legislative priority of expanding access for veterans wounded with wounds that the eyes cannot see. There are serious crimes that are included in the Veterans Restorative Justice Act, because these wounds to these veterans that served our country have serious wounds. They need our help. We are especially interested in the House language because it doesn't exclude people the way the Senate version does. We believe in no veteran left behind, that the Senate version does. We were hoping that, as I testified last week, that the House version would be enacted as is, because it's a companion bill for the exact same bill that was heard in Senator Limmer's Judicial Committee. We strongly urge that the House bill be passed. We were reluctant to accept the changes negotiated by Representative Feist and Senator Lang, but we accepted them. We do not want a good bill watered down to the point where it's a bad bill. Commander's Task Force is adamantly opposed to these changes that are being proposed. Thank you, Madam Chair.
Thank you, Mr. Johnson. I think I wasn't making introductory statements because I wanted this to go forward, but after these 3 testifiers, I think it's very important, especially for myself, in regards to this. This is not about do we or do we not support veterans. We do. We all do. And any statements to the contrary that say, just because you ask a question or clarify the bill language or have that discussion does not equate now you don't support veterans. That is wrong, and it is not helpful. And especially for me, growing up as a child of a World War II Navy veteran, the wife who sent her off to Vietnam with a 4-day-old baby and was at home. I am a sister to 5 veterans from Kosovo to Japan to Iraq to Vietnam, with grandkids, 1 out of active duty military and 1 in. We have veterans at this table here today. So we are all very concerned and very open to this discussion. But to imply somehow that one group doesn't get exactly what they want means you're opposed to veterans is not helpful and is not accurate. So I just want to make sure we start from that premise as we go forward and have this discussion. In regards to continuing our discussion, I'm going to have Senator Limmer join us now, and he has some comments to make for us today. Welcome, Senator Limmer. Glad you are able to make time to join us today. And if you want to go ahead and give your remarks. Need to be unmuted, just.
I have a touchy mute button, Madam Chair. Sometimes it works, sometimes it doesn't. I want to thank the committee for giving me this opportunity to talk regarding this very important issue. Before I begin, I'd like to make sure you realize that I too share your views, Madam Chair, about the perspective on veterans. Simply because we may have a difference of opinion regarding what the best veteran court could be does not in any way imply any negative connotation toward veterans in general. I too have family members that have been veterans, some of which suffered horribly under Agent Orange in Vietnam experience, as well as my father's experience in Korea. Having said that, I am aware that this version, the Senate version of the Veterans Restorative Justice Act, is different than the one in the House. There was conversation that the Judiciary Committee gave at a hearing, or the original House bill, a hearing in the Senate. That's true. We gave it an informational hearing. Matter of fact, there's been a lot of discussion about how do you justify previous votes on a veterans bill in earlier sessions. And quite honestly, that bill never had a hearing on those votes in the Senate Judiciary Committee. So we were flying a little blind without the scrutiny and the participation of the Senate Judiciary Committee, which I find to be very, very important to bring up. We did have a rather robust conversation a few weeks ago when we had that informational hearing, and we gave advocates time to express their perspectives while also having testifiers from the courts and prosecutors available to point out the high-level substantive issues within the language. One thing I wanted to point out is the one line that sticks out to me as I read it is line 2, or page 2, line 3. And that's where the key word is, where we as a legislature are dictating to the judicial branch with the word use shall as opposed to may. This is much more important than a lot of legislators realize. That causes a lack of judicial discretion. Judicial discretion is key to any court case. Judicial discretion is when we as a legislature hand off in policy the directions to the judiciary. And we're very careful not to overstate or dictate that process to the third branch of government. That's an independent branch of government, but it's also interdependent on some of the words that we give them. It's vitally important that we understand that. And I know in the past, we have made mandatory demands of the judiciary, and quite honestly, they are not always followed. And they have a right not to follow it. So we have to make sure we realize that. We have mandatory sentences for those who use guns in the commission of a crime. Only 40% of those guilty convictions actually are ever under the use of mandatory sentences that we, the legislature, have told them to follow. So just because we put it into our proposals and pass it into law, they have a right to dismiss it. I consider it a lack of judicial discretion, especially using that word shall versus the court may. The language does not take into account the positions or the wishes of the sentencing judge or prosecutor. If similar to the House bill, there's a large category of applicable crimes, including violent crimes, that are included that have a potential violent criminal history of eligible defendants. It's important for a sentencing judge to understand the criminal history of those eligible defendants. There's also the question of equal treatment under the law. This treats veterans different from similarly situated offenders, such as traumatized cops, EMS workers, domestic violence victims, victims of sexual and/or child abuse, things like that. We isolate this focus and concern only on veterans, and then create a court system to handle it. Now, I'm not opposed to a veteran court. Matter of fact, there's 9 district courts that allow veteran courts. That has been established by the administrative wing of the third branch of government, the Judicial Council. They are the ones that consider and analyze and listen to public testimony regarding potential changes to the court system. I find it to be a very thorough process. They take their job seriously, and any suggestions that come before them are also taken very seriously. I do not have any evidence of the promoters of the House bill ever going to the Judicial Council. And so I'd like to know that history a little bit. But quite honestly, I believe that the court system, if approached correctly, would consider such a move. And perhaps they would consider expanding their 9 veteran courts to a larger number. That would be effective across the state of Minnesota. In general, there is not a real comparable framework in existing law. The similar provisions we do have in existing law are different from this. When one considers the breadth of the bill, types of offenses covered, nature of the conditions covered, a lack of judicial or prosecutorial discretion, there really is no comparable provision in criminal law. Again, I'd like to summarize. I believe this is an issue of separation of powers. By dictating to the courts, the word shall has an entirely different meaning than the word may. I believe it interferes with judicial process of the courts. And also, the issue has to be raised about the equal treatment of a defendant under the law. That's key to our constitutional system. Equal treatment under the law means that I, as not being a veteran, will be treated differently by the courts than if I was a veteran. Therefore, I understand that there's a significant background to veterans that may have a distinct pattern of behavior that may influence their future behavior. I understand that. I believe the Minnesota court system has recognized this issue as well. Their system of veteran courts, I believe, are working, but I believe it probably needs to be nudged and suggested to the court system that we should expand that. My purpose of being in front of this committee is to recognize that there are limitations to the legislative branch. Quite often, we treat the judiciary in this state more like a government agency and department rather than its rightful co-equal status as the third branch of government. And I believe that respect should be seen in the legislation we pass. We can urge, we can recommend, or we could put into writing the word may to give not only direction, but recognize the status of the third branch of government. Madam Chair, I'll conclude my comments now.
Thank you very much, Senator Limmer. It's good to hear from you directly today on this very important issue that is in the state government bill with military and veterans affairs that might otherwise be more in the purview of the judiciary. So it's very important to hear from you, and I appreciate your taking the time to be here. We do have Mr. Kemery here, but his substitute speaker was Tommy Johnson, and he has already spoken. I will be glad to give Mr. Kemery some time, but I also want to say that there may be questions from members as well. And if you might go ahead and raise your hand if you would like to have, to be on the list for asking a question. All right, in the meantime, I will go to Mr. Kemery, and you can go ahead and give a couple of some remarks, and then we'll go to questions. Mr. Kemery? All right, we're going to move on. And Representative Greenman, I see you have your hand up. Would you like to ask a question?
Yeah, thank you, Madam Chair and members. I do have a question for our testifiers, and just after listening to all of them, and I'm wondering if Mr. Ward, he raised, I think there's lots of areas in our law, mandatory minimum penalties for DWIs, mandatory minimum penalties for repeat domestic offenders, and the stay of adjudication that we have that's mandatory in the drug sentencing laws, which I think he mentioned. I'm wondering if he could speak to the separation of powers issues that we heard about from Senator Limmer.
Representative Greenman, did you have that going to a particular person or just whoever?
No, so I'm interested in the testifier, Bill Ward, speaking to that.
Oh, Mr. Ward, okay. All right, thank you. I didn't catch that. Mr. Ward, go ahead.
Madam Chair, Representative Greenman, I believe that Ben Johnson from House Research is also on this call that could answer that with the actual case law and cites. And I appreciate Chair Limmer's concerns about separation of power, but the reality is that the legislature is the body that not only creates the law, but also recommends sentencing. And while Representative or Senator Limmer, states that the courts are not following it in some instances, the goal, I believe, of legislation is and the Guidelines Commission is have consistency across the state as to how people are sentenced. And it shouldn't matter the geography in which you live. So it's the legislature that creates the laws. It's the legislature that says what the penalty is. It's the Guidelines Commission that ranks it as to where it should be. So I don't find this as a separation of powers issue. I think esoterically we can always argue one thing or another, but the court does not create the laws. The courts implement what the laws are as far as how they sentence individuals. The reality is that with our guidelines, we wanted equal treatment. And some would say that the mandatory minimums would take away that discretion from the courts. But again, we don't seem to have a problem with it when we're sentencing individuals to certain mandatory minimums. And we also didn't have a problem with it with taking away the discretion on stays of adjudication. So clearly, these laws have been in existence for a long time, and I'm not aware of any challenge that's been upheld that said that the laws that were enacted that you've just described and I've talked about in any way violate the separations of power doctrine between the House or the Senate or the legislature and the courts.
Thank you, Mr. Ward.
Thank you.
Representative Greenman, did you have another question?
I did, sort of a follow-up, because the way I read the House language, there's actually quite a bit of discretion for the judge, both at the beginning to determine eligibility. It says that they shall be given this opportunity, but the judge has the opportunity or has the discretion to determine the eligibility components. And then later, I think as I think one of our testifiers referred to on sentencing, the judge has the discretion, and this is as a former public defender where I know a lot of the judicial discretion comes in, has the discretion to weigh both whether the program was successfully completed. And so to me, I think this actually does a really good job of balancing, ensuring that we are treating all veterans fairly, and to what Mr. Johnson said, leaving no veteran behind, but giving the courts and the judge actually the places where discretion really matters. Is the veteran eligible under the way that the legislature lays it out? And once the program has been, once they've gone through the program, do they have the ability to, have they completed the program? Have they successfully participated? And so I'm wondering, and I don't know if this is a question, but as it relates to judicial discretion, to me, that seems to satisfy and really give the courts a role in this, while ensuring the consistency that we're treating all veterans that we say in statute are eligible with the opportunity to get into this rehabilitative system.
Okay.
So that,
Thank you, Ms.
Madam
Greenman.
Chair.
Thank you, Representative Greenman. And then I will go to Representative Zhang.
Thank you, Chair Kifmeyer. I have a question that might be for Mr. Ryan Else, if he's still here. I would just like some clarity on exactly what the judge might have to do under this bill, because we're getting some jumbled different opinions on this. So maybe Mr. Ryan Else can talk a bit about that. Thank you.
Thank you, Representative Zhang, and we'll go to Mr. Else. Mr. Else, you're just a reminder for those, if you, again, just go ahead and answer the question from Representative Zhang.
Thank you, Chair. So the judge has a few steps in this process. The first will be the eligibility determination, and that's where the judge has to make a finding as to whether or not the crime was committed stems from a service-related disorder or mental health condition, substance abuse condition, something like that, that caused the crime, and that stems from their military service. So once that eligibility determination is made, the shall language that was raised by Senator Limmer comes into play and says, at that point, the judge shall enter the veteran into a treatment program that is supervised by the court. And then the veteran has the responsibility to prove up that they successfully have rehabilitated, that they no longer pose a risk to public safety. And at the end of supervision, there is a hearing in which the judge hears the victim, the prosecutor, and the defense as to the pros and cons of the veteran's rehabilitation. Did they successfully complete treatment? Are they any longer a risk to the public? What is the harm to the victim, and how does that balance with the treatment that they have performed? And if the judge determines that at that hearing in the favor of the defendant veteran, then the case will be dismissed. But the judge has the discretion at that hearing to say, no, you have not performed well in treatment. Yeah, you showed up, but you didn't really rehabilitate. I still think you're a danger to the public. Or even the harm to the victim was so great that I just can't grant this dismissal. And that is where there is plenty of judicial discretion. The shall is only for the opportunity for the veteran to prove to the court that they've rehabilitated.
Thank you, Mr. Els. Representative Zhang, do you have another question?
Just a follow on that, Madam Chair.
Okay.
And so that's, you explained it, I guess, as shall, if it were shall, and what if we were to insert may into the language? What would the different outcome you foresee?
Mr. Els.
That's a great question. So what the point at which that would change is the court would still make that eligibility determination at the beginning. They'd say, yes, you have an offense that is related to your service-related disorder. But then at that next point, the court would not have to enter the veteran into the treatment court program and could just have them sentenced and go through the normal criminal path. And in which case the veteran would not be forced into any of the treatment. And as a veteran who's gone through this treatment, I can tell you it's terribly difficult. I had to be forced with the threat of divorce. That was how I got through it, because it's miserable. You relive the worst moment of your entire life over and over and over again until you're comfortable with it. It's miserable. And the reason we, with the prosecutors agreed and everybody on this working group agreed that this should be a shall directive to the court is that it shall get the veteran into treatment, and it shall use the case as an opportunity to force that veteran to get through the treatment, because it is a process that is hard enough that it needs an incentive to keep you from quitting. And that's where the shall is. But then if that veteran doesn't do it all the way, the court will still have the discretion to deny the dismissal, which is the benefit to the veteran. So, this shall is really not a directive to the court as much as it is a directive to the veteran.
Thank you, Mr. Els. Representative Zhang, did you have any follow-up?
I had a different question, Madam Chair, if that's okay.
Yes, Representative Zhang, sorry. Please go ahead.
Thank you, Madam Chair. I also, we talked a bit of, this may go to Mr. Els or Mr. Ward. We talked a bit about access to veterans. Is it correct that this bill is only for veterans to seek treatment? Because, we're talking about equality of sentencing, equality of treatment. Maybe even one of the two can talk a bit about that.
Mr. Els, go ahead and answer that question, please.
Thank you, Madam Chair. The equal protection debate has come up a lot in the context of veterans courts. It was originally raised by the ACLU back almost a decade ago. And the reason that is no longer a concern for anyone is twofold. One is that a veteran defendant is very unique in the criminal justice system in that they are the only defendant in which the government is the one who created the criminality. The veteran comes into the military and is, by all accounts, by the military's own accounts, a good enough citizen to get in. They have to pass drug screening, they have criminal background checks, they have to meet aptitude testing, and they go in, and so they are not evincing any criminality at that point. They have this trauma in war or otherwise in their service. They come out, and because of that trauma, they are committing crimes that they would not have otherwise committed. That role of the government that is now prosecuting them in creating the conditions that the crime was committed in is a consideration that can't be ignored here and makes it very different from any other defendant. Additionally, this is not a free pass. As I talked about, the treatment is terribly difficult. And we're not saying just because you're a veteran, you get this pass. It's saying if you can prove to the court that you're no longer a danger, then you can avoid the record of conviction. And frankly, I would encourage legislation like this and for other victims of trauma. But at this point, We have to deal with the people that we have sent into the longest wars in United States history. And some of these guys have had 4 or 5. We have one veteran with 13 deployments that Mr. Hunter and I have represented. The government has a responsibility to these people that it does not have in a normal criminal case.
I have a question for you, Mr. Else.
Yes, Senator.
So, Mr. Else, does every veteran who returns have these issues?
Not at all.
Okay. Another question I have for you, on the number of deployments, is that the choice of the soldier to have additional employments, or is the government mandating another employment?
As long as they stay in the service, they have to do what the service tells them.
My understanding, Mr. Else, is that the soldier decides whether to do another deployment. It is their choice on how frequently to deploy. Now, it's very heartwarming when we think of those who are willing to do more, but just to remember that it is a choice as well as not. And so my experience has been in the past that there has been a choice, but I'm going to turn to Senator Howe in regards to these deployments. Senator Howe.
Thank you, Madam Chair. And I think that
Just a moment, you've got to turn off your mic. No, not that one, the one on your computer. And the. Try it now.
you can see how many times I've done this hybrid stuff, so.
I know.
Anyway, I think in the past, it used to be where we used to have a choice whether we go or not. But talking from experience, that's not the case any longer. You end up getting transferred to another unit, and that unit's on the docket to go. As long as you've had dwell time, and I can't remember what the current dwell time is, it has changed, but as long as you've been back in the States for at least 90 days, and then I think as a minimum if you volunteer to go back, but I believe it's something like 2 years, you're on the docket to go again. And so I know I've had soldiers that have volunteered to go on additional deployments relatively right after they get back, 90 days later go again, and they've done 5 or 6 9-month deployments. Myself, I did a deployment, and 2 years later I was on another deployment whether I liked it or not. So it has changed over time. So the op tempo of what occurs in today's Army with the shrinking of the military and what they need to have done, that option to decline, as long as you've had a certain amount of time back in the States, what they consider stateside dwell time, if they tell you to go, you don't have a choice. So that's I think that's today's version of what happens now today, so.
Thank you very much, Senator Howe. I really appreciate that. So at this table here, we have experiences from previous times, and then we have that, and I really appreciate. But what I want to do here, though, is, Mr. Else, to make sure that as the public hears this, that there is a mixture. There is a time at home. Some of them are voluntary. Some of them, we need you. You have unique skills. So I want people to understand it isn't just as the government sent you these numbers of times, that it's always dictated through that.
And may I make?
Just a moment, please, Mr. Else. Just a moment, please. I'll call on you. In regards to the stakeholders, I think what I'm having a challenge here is some of the statements, Mr. Else, that you have made in regards to the Senate, and especially the work that Senator Chamberlain has done and other members of the Senate has done, the lack of recognition for a significant amount of time and efforts that has gone into it. The other thing is I consider the courts a stakeholder. When we hold hearings, We have a variety of stakeholders, and we consider them all, and there is no issue with considering other stakeholders, and that we don't always just take the position of a particular set or group or a stakeholder. We try and include those. So I think that's important to just kind of keep that in mind. Mr. Else, did you have an additional comment on this point right now? Otherwise, I have two members who have a question.
But as to your point about the Senate, I applaud all the work of Senator Chamberlain and every other senator that's worked on this. And if I came across as not doing so, I apologize. My concern is that the Senate version in front of us on the side-by-side has the prohibitions on crimes of violence and domestics, I think that misses the point of the bill.
Thank you, Mr. Else. I appreciate that. And without question, we have acknowledged that there are differences between the two, and we're having an open discussion right now as to those things, but to portray this as somehow the Senate would not be accurate or fair, and I think it's very important that we recognize that as we continue with this discussion. With that, I'm going to go to Representative Mason. Actually, you know what? I've taken two representatives in a row, so how about if we go to a senator?
Okay.
I'll come back to you, Representative Mason. Senator Carlson, you're next.
Thank you, Madam Chair. And, you know, a senator is always equal to two representatives anyway, so we'll just kind of go.
Senator Carlson, we can hardly hear you right now.
Oh, let's see.
Just lean into your microphone, sometimes
like a
leaning a
little
little
closer
closer
here?
to your laptop.
Yeah.
Yeah.
You know, my comment was that I think a senator is worth more than two representatives anyway, so we'll just kind of leave that go as it is.
Oh, dear, oh, dear. Senator Carlson, you are digging a hole here.
Yes, but I have a question for Senator Howe. I am not a veteran, and I appreciate his service, and I appreciate immensely his perspective on this. And what we were talking about was how much of the redeployment is optional and how much of it is mandatory, and when is it a little bit of each. And Senator Howe, what I sense from veterans is that they're a very close community, and they get that closeness from serving together. And if there's an opportunity to go to a second deployment, how much of that is kind of this magnetism of being close to your community? And, you know, even though maybe there's something that you're not comfortable with, but it is going home to your community. And, you know, and I guess that's where I'm coming from is that, you know, there are things that develop, mental conditions, things like that, that, you know, you don't evaluate them completely and fight against being redeployed. You want to be with your community. And so I'm thinking, what do you hear and feel from other veterans when they are being deployed? Do they not want to be deployed? Are they seeing this as their responsibility? I mean, veterans are a group that feels strongly responsible. So do they feel responsibility to go for a second, a third time? Well, you know, I guess I'd really appreciate your perspective on that, and I really value it, and I really thank you for giving us a little bit of perspective from the first person.
Thank you, Senator Carlson. Senator Howe.
Well, thank you, Madam Chair, and thank you for the question. I guess that is all over the map because you don't always stay with the same unit. I mean, when you first deploy with a unit, you've got bonds that you develop that are stronger than any other deployment you're going to go on, generally speaking. But that's not always the case, and there's times when you get moved to a new unit, and that unit's going, and they have to fill a slot, and you've got the technical expertise to fill that slot. You get pulled out of your unit, put into a new unit. You might know a handful of people. You may not know anyone. So, you know, there's times when you get an opportunity. You get into a unit. You've developed relationships, and that unit gets the notice to go, and maybe you haven't served your dwell time yet, but you've developed those relationships, you probably are going to volunteer to go. But that's not always the case. There's many times soldiers, just because of what their technical expertise, that may be in an area that doesn't have a whole lot of people in that job specialty, that you have the unlucky number that gets pulled all the time, and you go more often than others. So it's a crapshoot. It's all over the map. And there's people that, I will tell you, after I first got back from my deployment, even though I really wanted to be home, I didn't fit in real well. And you'll find that experience. And so I actually wanted to go back at that time because life was much easier because it was all laid out for you. Trying to decide what you were going to wear was all taken care of. Where you were going to eat was all taken care of. What bills you had to pay, you didn't have that problem. So life was a lot simpler when you were in the theater of war. But all you had to worry about is trying to stay alive in different situations. So it's all over the map. You can't put you can't put this thing in one box. It's all over the map. So a lot of different experiences for a lot of different people.
Thank you, Senator Howe. I think that's really great insight. I'm smiling a bit because my sister came back from a one-year tour, and I checked in with her a little while later and asked her what was the most difficult thing to adjust to when you returned home. And she said, well, the next morning I woke up and I realized I have to do breakfast. I don't get to go to the mess tent and just eat. Oh yeah, I have to do laundry. And the husband, her husband is like, oh yeah, I need to talk to you about what time to take the kids to school and who's going to do it. And re-entering into, as a matter of fact, Minnesota has a very strong re-entry program. They work very hard at helping the soldier not just to adjust to leaving and serving, but also in that return because of those kind of adjustments. Those are real and very, very important to recognize that. Thank you, Senator Carlson, for asking that. Okay, we'll go to Representative.
I do have a follow-up.
Okay.
Thank you. I just wanted to say one of the things that really causes me to be strongly in favor of this is an experience I had, which was, I don't know how frequently people have this experience with a veteran, but the clerk at Radio Shack. Now, this tells you how long ago it was, but I met the clerk at Radio Shack in Eagan, and we talked a little bit and got to the point where he told me that he had been deployed. And so I asked him more about it, and it took him a little while to kind of warm up to me a little bit, but he told me that he had been in Iraq and he was on the streets, and this was early in the theater there. And I said, how did it affect you? And he said, well, my father died and I got a time off to come home. When I came home, we had a family gathering with my father. It was at my father's funeral, and I beat up my uncle. And he was arrested and taken to court, and the judge let him go because he was on temporary home leave. And he said he went up to Minneapolis with some friends, got into a bar fight where he beat up a couple of people. So he said, I can't take people that criticize me. I can't take people that I have a problem with anymore. And he said, and besides that, right now, I don't stop for red lights. I go faster when I go under a bridge. There are all these behaviors that has changed him. And I'm thinking that if he doesn't stop for red lights, that's a crime. And if he's going, speeding under bridges, that can also be a crime. But it all comes from his experience. And his experience has now changed him for the rest of his life. I don't know where he was as far as how far he was or how long he was out of the services, but this is a guy, and by the way, I did stop back at that Radio Shack, and he had been fired for evidently having a fight with not a physical fight, but having an argument with a customer. So there are people like that we really need to make sure that they get the chance that they deserve for the things that we have asked them to do for us. And that's where I feel is I'm not a veteran. I did not qualify to be in the services, and they did it for me. And now I owe them a little bit of compassion on getting their life together for the rest of their life. And this guy was young, so he's got a long life to go yet.
Thank you.
That's where I come from.
Thank you, Senator Carlson. I think I'll affirm again, we all have and share that compassion and gratitude to our veterans and all of that that implies as well. I would like to say, though, that there's a difference between a contributing factor and a cause. The judicial system heavily considers contributing factors in a whole variety. In almost every criminal situation, there are contributing factors, and they are taken into account by juries, taken into account by judges. But to say that every vet returns and then these things are causative are very different. I think it's a matter of contributing factors in unique circumstances, which I think we do have a great appreciation for the uniqueness of that, and so I want to understand that. I do have some questions. I'm going to go to you right now, Representative Mason. Thank you for waiting, and then I have a few questions I'll ask next, and then Representative Nelson, I'll go to you after that, if that's okay. Representative Mason.
Thank you, Senator. First, I have not served in the military, so I want that clear, nor am I a doctor or have any medical background. But I have observed people that have been in the military, that I knew them before they went in. I knew them again when they came out. And in some cases, the change has been dramatic. So those are my personal biases. But the question I have, it could be for Senator Howe or anybody else that has personal knowledge of this. If you are in the military and that is going to be your profession, how many times are you able to refuse being deployed and still be able to advance in your profession?
I think I'll go to Senator Howe for that, or Senator Lang. Guys, you can both answer. You're both military.
I will, thank you, Madam Chair, and I will say that refusing to deploy is highly detrimental to your the advancement. It's going to be tough to go anywhere, and it's going to be tough to be retained after your enlistment or when you come up for the end of your cycle. I think that's pretty much the kiss of death for any piece of that. But I'll let Senator Lang expound on that a little bit.
Senator Lang.
Thank you, Madam Chair. You don't refuse a deployment would be the answer. In my years in the military, I've seen it twice where someone has said, I'm not going to this deployment, I've been deployed before. Not going to do it, and their reasoning is they just don't want to. Immediately, those folks are flagged for what we call flag for reenlistment, so they cannot reenlist into the military if they're going to be a non-deployer. Now, what I would tell you is that each and every unit has discretion somewhat on who their staybacks are, what their rear detachment looks like when they're deployed overseas. Oftentimes, as a commander, you're going to use that discretion to the best of your ability for folks that have family issues, for folks that have personal conflicts, possibly. For folks that have a lot going on in their life, you may say, yep, you are what I consider not necessarily, you know, pertinent to the mission success when you go overseas. So we do have that discretion. What I can tell you is in the years that I've been in the military, I've been on 2 deployments and I would have been on a 3rd, and the only thing that's kept me from deploying is getting elected. So that was, I would have just gotten back from my 3rd deployment now if I wouldn't have got elected. So when I got elected there, they shoved me off on a shelf and says, go be in this other unit, and we'll dust you off when we need you. So you don't really have that option.
So I
Thank
have a
you.
question.
That was my
Representative Mason.
impression.
Thank you, Representative Mason. I would say also that folks sign up to serve in the military, and it can be 2 years, 3 years, 4 years, 5 years. That makes a difference as well. Some are deciding to make it a career and are looking for that advancement. Others are there to do their duty for 2, 3, 4 years, depending upon the branch of military or what they sign up for or their job skills. And so there's a variety of things that may come into play in regards to that. I think what I've heard them say before, it's not that absolutely simple. Representative Nelson, I was going to go through some questions that I have, but if you would like to go first.
Madam Chair, I just wanted to tell you, I got a text, and the reason Mr. Kemery wasn't able to speak to us today, and he wants to thank you for the opportunity, but that he was having trouble with his internet stability, and that's why he wasn't able to, why he got dropped off, and then when he came back on, he wasn't able to speak. So he just wanted to extend his thanks for being able to, or being on the list and being invited to speak.
Thank you very much. Matter of fact, I had a note here from Mr. Kemery as well to read that he was having trouble maintaining his connections, and he wanted to extend his gratitude and sincere apologies to the committee. I want to assure you, Mr. Kemery, no apologies needed. We appreciate your efforts and trying to be available, and look forward to any written testimony that you want to submit. And I believe we have heard from you before. It would have been good today, but we understand your situation. Thank you. I think a question that I have right now is for any one of our testifiers that we've had here. There is a current process for veterans in Minnesota through the court system. We kind of hear this bill as if anybody might be watching this, that it doesn't exist anywhere, and that is not the case. My understanding is that there are, I think the number I have is 8 current veterans courts. And the question that I have is, why can't we just expand the number of veteran courts rather than create this entirely new process? The concern I have is you have judicial rules, judicial council governs those, which is overseeing these current veterans courts that are currently and been spoken well of. Now here we have this kind of process, and how might those two conflict with each other, especially if we use the shall language? And so whether it's Mr. Else or Mr. Ward, if you want to respond to that, why can't we just expand the number of veteran courts rather than create an entirely new process? And how do they interact with each other? How do the rules of the current, which are well established, and then I'm coming to you, Mr. Else, and then how does that benefit? So, Mr. Else, if you could just respond to that general question.
Yes, Chair. There are, as you pointed out, there are about 8 veterans courts. I think they cover a total of 12 counties. That leaves, by my lawyer math, something like 74 counties that do not have veterans courts. And that is the target audience of this bill. If a court has a veterans court, then this bill will do nothing more than direct that a stay of adjudication should be the legal benefit that the veteran receives, which is the case in, I would say, 6 of those 8 veterans courts that you referred to. But this bill will help the counties that don't have the resources or for whatever reason have not set up a veterans court themselves. This will allow a judge to have a veterans court-like process without the cost of the staff. A Veterans Court staff is usually somewhere between 20 and 30 professionals that sit in a room before the Veterans Court. It has a full docket. It costs a lot of money, in a court, you know, a rural court that has 2 judges cannot really have a whole day once a week that is dedicated to Veterans Court, where they bring in all their probation agents and staff from the VA and all of that. So this is something that allows that court to use that same process that is used in a Veterans Court as close as they can with the resources they have, and it directs them through that process.
Thank you, Mr. Else. So as close as they can with the resources they have. So the situation here is that because we would pass this, there's no guarantee, according to you, Mr. Else, that this would happen, because as close as they can with resources they have means that in some of these places where it takes 20 to 30 staff and only 6 of 8 do a particular type of adjudication, if I heard you correctly. And so I think that's an important information for us to carry. Another question I have for you or Mr. Ward, have you visited the Judicial Council? And just for the interest of folks out there, Judicial Council is the administrative entity for the 3rd branch of government, the Judiciary, okay? They have an administrative entity, and it's called the Judicial Council. They have public meetings, and they control the rules and policy of treatment courts. That is done under the Judicial Council. So have you visited or gone in front of the Judicial Council to talk to them about the changes they would like to see in the system or not? So Mr. Else or Mr. Ward, if you want to respond, and I see Mr. Else, your hand up is, so I'll call on you, Mr. Else.
Thank you, Madam Chair. Yes, when we had this working group that drafted the language that we initially brought before you in 2018, in that spring, Judge Renee Workey of the Court of Appeals arranged for us to present to the Treatment Court Initiative on the legislation being drafted. We also had judges that were on that working group. Judge Renee Workey was a liaison between us and the judicial branch. And so we were interacting with the courts all the way through, including the Treatment Court Initiative with the Judicial Council.
So,
Madam
Mr.
Chair, this is Bill Ward. Can I address?
Just a moment. Somebody is speaking. I don't know who you are.
Madam Chair, this is Bill Ward. I was wondering if I could
Okay,
address
just
the
Mr.
question.
Ward, the rules of a committee are you wait. I appreciate if you can put your hand up, either your literal hand or the hand on the Zoom screen. Either way, let us know, and then I will call on you. So, Mr. Ward, I'll call on you now to respond.
I appreciate, I apologize for violating the rules. You make a point about Mr. Else saying as close as we can. The reality is one example is Washington County, which does not have a veterans treatment court as designed as the other 8 that you mentioned, and yet it has been very successful in following the protocols that are set forth in this particular bill that's been drafted. The goal here really is, right now, the veterans' needs are not being met at all in 75 counties. And we recognize that this bill is not the panacea. We do not have the resources throughout the state for every county, nor the human resources to set up treatment courts in all 87 counties. They don't exist. What we were trying to do with the vets, as you very well recognize, is the needs that we need to address for them is give guidelines and give opportunities and resources for veterans throughout the state by following this protocol and providing the resources at a local level, even though a veterans court, a treatment court, has not been officially created in those particular counties.
Thank you, Mr. Ward, and I will emphasize for everybody who's listening today, the reason for waiting to be recognized is, first of all, an orderly process. But the other thing is there are those who only have an audio opportunity. And if we don't call on them and state their name or their multiple voices calling out, That makes it very difficult for those who do not have Zoom, do not have video capabilities in a variety of ways, and only have audio. So these are rules that are very, very important to consider other people who are maybe not in the same position that we are today. So I just want to emphasize there's a reason for those rules. And so I appreciate hearing that, Mr. Ward, and appreciate that very much. Now, the question that begs itself, we have current treatment courts. And so whether it's Mr. Else or Mr. Ward, we have current treatment courts. The question I've asked before is, they have rules, they have judicial policy rules. You've mentioned Dakota taking their own pathway as far as what they are doing. Sounds like modeled upon what we have right here. If they're able to do that, and do that right now, but the big thing is the current treatment courts. What is not working in the current treatment courts that you have in the language we have before us today? Mr. Else or Mr. Ward? Mr. Else, are you?
Yes,
Okay.
I'm able to answer that. What's not working is the disparate treatment. The reason the working group assembled in the first place was to deal with the fact that you, at that point, where if you were a veteran in Hennepin County and you committed your offense on the other side of the county line into Anoka, you could get totally different results depending on which court you were in. A Hennepin County veteran at the time we started this working group would have been convicted of the offense, and an Anoka County veteran would have gotten a stay of adjudication like in this bill. This will bring all of the veterans into a similar treatment, and they will have the same legal benefit to the work they put into the court. And perhaps most importantly, the rural courts will also be allowed to grant these stays of adjudication that currently are really being given only in the urban courts, such as Hennepin, Anoka, Washington County, St. Louis County. That these are kind of limited to veterans who are located in cities, and that simply isn't fair.
Thank you, Mr. Else. Representative Nelson, you want to chime in on this?
Thank you, Madam Chair. And I guess what Mr. I'm not, yeah, I'm unmuted. Thank you, Madam Chair. What Mr. Else just said tripped something in my brain here. What's the difference, and what difference could it make to somebody to say, and you were talking in Anoka County, they don't have a conviction on the record. In Hennepin County, they have the conviction and then they go through the treatment. What difference can that make as the person's coming out of the treatment and out of the courts and successfully completed it by having and not having a conviction on their record? I'm thinking about places where they rent, landlords that don't take people with convictions. I'm thinking jobs that require a license. Even in my trade, there's you have to go through background checks to do work sometimes at the nuclear facilities in Monticello, where our carpenter members go up there and work. So what difference could it make having that conviction on your record or not on your record, Mr. Else or Mr. Ward?
Mr. Ward?
Thank you, Madam Chair, and Representative Nelson. You just stated it. It makes all the difference in the world. We call them collateral consequences, but the reality is it's life-changing. Having conviction affects an individual in every area that you just mentioned, including being able to be a barber or a hairdresser, let alone obtaining perhaps student loans or housing, as you just mentioned. So that conviction is enormous, and it has an enormous weight and albatross over someone's shoulders as far as moving on with their life. And that's the reason why we are so passionate, as all of you are, about helping the veterans, about giving them a second chance. And that's the reason for why the bill's language was drafted the way it was.
Thank you, Mr. Ward, and Representative Nelson, no question about it, I would say. If you are able to not have a felony on your record. There are many things that are happening different in your life. It makes a big difference to that. Representative Nelson, do you want to follow up?
Not at this time, Madam Chair.
Yeah, thank you. Mr. Ward, did you have another comment?
Madam Chair, my only comment was it's not just a conviction for a felony, it's a conviction for a misdemeanor as well as a gross misdemeanor. No matter what the level of offense, it makes a huge difference in someone being able to move forward. So literally, it's not just the felonies. And I appreciate your comments on that.
Thank you, Mr. Ward, for clarifying that. I didn't want to get into the listing of them all. I should have just said any offense in regards to record, but thank you. I appreciate that very much. Okay. Before I go to you, Ms. Representative Greenman, I'm just going to do another question I have here. One of the things that I see is we have this language here before us today, and then we have the current treatment courts. I think I've asked this question a little bit before. What happens if this language would go into law, and in whatever shape it does? How does that impact the current treatment courts? Mr. Else, did you want to respond to that? It looked like you were looking to do that. Mr. Else.
Yeah. The only impact it would have on any of the treatment courts would be directing the sentence. It would, if a court is not granting a stay of adjudication, it would direct the courts to do so. But otherwise, it would not affect their operation at all. They already are doing these things such as determining eligibility and then bringing the veteran into the court. And all this would do is direct the legal benefit that the veteran receives for doing the treatment they would otherwise do.
Thank you, Mr. Else. I think that is interesting because most generally, when you have a current process, there is interaction with that, especially when you do the shall, because it's a little bit more complicated than that. I have some more questions, but I'm going to go to you, Representative Greenman, to go ahead and. You're unmuted, too.
Thank you, Madam Chair, and I really appreciate this discussion and want to sort of ask a question we've been talking a lot about the impact that this is having on veterans, and I know another piece of this is about public safety in communities and families. And so and I know, with Violence Free Minnesota, the county attorneys and the public defenders sort of all being invested in that piece too. And I just, as a former public defender, I know that oftentimes clients would actually not choose the treatment option because, as I think Mr. Els described, it was a more onerous, it required, and oftentimes was a longer process. And so I know from talking to folks involved in this process that piece of getting folks into treatment is actually critical. So I'm wondering if maybe this is to you, Mr. Ward or Mr. Els, but could you talk a little bit more about the public safety and sort of community family safety impact that is going into this and how specifically the language will provide that?
Mr. Els, I think that was directed to you at this time. Mr. Els.
Yeah. Thank you, Madam Chair. I think an example of a veteran that we represented is probably the best illustration of why this is good for public safety. We represented a man that's testified before the Senate before, so I'm happy talking about him publicly, named Marko Milosevic, who was a 13-tour Army Ranger working at the very top of the special operations community. He had a firefight where he killed over 40 people to display the dangerousness of a person like him. He had a domestic assault in Bemidji, Minnesota. And when we were going into the sentencing process there, we got him a stay of adjudication like this bill grants that was all contingent on him going through treatment. And he's done beautifully since. He's got a 4.0 GPA. He's considering law school. He's going to be a beautiful asset to our community, just like he was to the Army. But he said to us at one point, it's a good thing this happened because if I had been a felon, I would have been a really good felon. And I think we really need to heed the warning in those words. These are people that, if they've been wonderful assets, and most of them come back and they are wonderful assets to the community. But if those skills are turned in a way that's dangerous, it's dangerous in a way that no other member of our community is dangerous. The skill sets that they have are frightening. And when you're talking about an infantryman with multiple tours, I was a National Guard infantryman, and the level of violence that I was trained in really scares me looking back. And before I dealt with my own problems, I was afraid. I don't like what I would have been capable of if I had gotten in a bar fight or just any of the simple things that lead people into community acts of violence. We need to see that danger, and in the very few veterans, this is the minority, and I want to stress that point. This is not all veterans are dangerous, but in the minority who come back and they have a mental health problem that causes them to act out criminally, we need to grab that opportunity to address that service-related disorder, get it fixed, and so they can be assets to the community again, and not a terrible danger like they can be if they're forced into a life as a felon.
Thank you, Mr. Else. I'm going to go to you, Mr. Ward. And something you said, Mr. Else, that this is a minority, that it is not everybody, but with their skill set. I recognize that. I think of the training that soldiers had. I just remember so vividly. I think I went into a movie, actually, in Paris on a train, and there were terrorists, and there happened to be some well-trained veterans on it, and their training took over, and they were able to make sure that the end of their effort came about quickly because of their actions, and that is often the case as well. Many times these soldiers are in this situation. Okay. We're having, not only Mr. Kemery is having trouble with the internet connections, even here at this table, this is my second time being bumped off as well. So I really appreciate that, the fact that there are many soldiers out there, many returning soldiers, who their skill set has been tremendously helpful in community instances of great need. And we're talking now about particular situation, but there are also many others where their skill set and their training has been tremendously helpful to their local communities. But we're dealing now with those who are in a little different situation. I'm going to go to Mr. Ward.
Thank you, Madam Chair. I just wanted to parallel what Mr. Else was saying as part of the working group discussions, and we would learn the life stories and the concerns that the council had with their clients, and also that clients had expressed to us. And the question was posed to me, well, what needs to happen so we can truly protect and ensure public safety? And what needs to happen as part of this model that we would encourage our clients to participate? So that's how this model came about. Was as a lawyer, if a client comes to me, and again, think of how difficult, as has been described, developing a trusting relationship with a client about his or her needs moving forward. We try to address the best we can, but in the court system, that's oftentimes very difficult. In a number of the older veterans court treatment models, I wouldn't refer my clients to them because you're referring them into a conviction, and yet they still had to go through the arduous process of going through the counseling and the treatment and the rest of it, but there was really no benefit to it, and it was a longer period of time that they were under these conditions of probation. So the easy thing is, and this might sound terrible to you, but as a lawyer, the right thing for me was to do what was right for my client in that given moment to ensure that he or she did not recidivate. So the idea behind this model was, how do we get a process in place where I would refer clients knowing that they would be treated the same no matter what county they were in, knowing that even if a veterans treatment court model didn't exist in the county, that a statute was to be available to allay them to be able to access those resources. So I think that's an important part of the discussion as to how we got there, because you got to remember, I represent nearly 90% of all the accused in this state. And to make sure that we were addressing those in my agency, a model needed to be put in place that would be fair throughout the entire state.
Thank you, Mr. Ward. I appreciate that. One of the concerns that I have, though, is unrealistic expectations. The reality is the goal is to have this in this particular language to be available, but then closest can and with the resources we have, that in these veterans courts that have them, they're looking at 20 to 30 staff. This is a practical, pragmatic reality, but also making sure that we don't create expectations that the system is not able to deliver. So, Mr. Ward, I'll go to you to comment on that.
And Madam Chair, I appreciate those comments. Trust me, we had those discussions over and over again. And what this bill does is it changes the lens of how we look at veterans. It's not a one-size-fits-all. I don't mean to demean anyone in this, but when a veteran comes in, we need to look at him or her in a different way and to provide resources in a different way. What that would mean is that, yes, they would report more, but that same individual would be on probation anyway. Yes, we would use resources, but now we can use the VA resources and the VA individuals who would also be a part of these discussions and the resources too. So it's using resources in a way that is targeted for people who truly, potentially, could be a public safety concern, and treat them in a way that's more focused than you would on a typical theft case, for instance. So it's changing the lens. Yes, it is unique. But it's changing the lens and looking at the individual and not the charge and not the actual sentence. So that's the purpose. We're not saying this is some sort of panacea, but I firmly believe, otherwise I wouldn't be sitting here now, I firmly believe that this is a wonderful step to have all the counties to be able to avail themselves of a process and potential mitigating sentence if in fact they follow these conditions.
Thank you very much, Mr. Ward. And by the way, when you say again and again, I think I've heard you testify once or twice or three times. These are not some things that it is very helpful. We all learn by repetition, and we all cannot totally absorb everything that is said in any one individual time. I sense sometimes a degree of frustration with that. I appreciate that. I understand that. But part of this process is to be able to do that. One of the questions that we have in veterans benefits, in order to get a disability benefit, you have to prove that it is service-connected disability. That is just a general statement. I'm not claiming to know everything about this, but just because you leave service and may have other issues, there is a process you go through to have it determined that that is the case. So in this particular case of going through this special court process, is there something similar to this, or is it a presumptive? So is there something that in the interview, assessment, or so on with the veteran that is looked upon, that there is specific trauma, traumatic event setting, so on and so forth, like there might be with a service-connected disability? So is there anything like that in regards to this, or it is it presumptive? You've been in the military, you've served in these sorts of situations, and then it's presumptive. Mr. Ward or Mr. Else, do you want to address that at all? Mr. Else? It's
Yeah.
nice to have two of you here. You can kind of take turns.
Yeah, I get tired sometimes, so it's great. Yes, Madam Chair, the the eligibility determination in, I'll use the House version as a reference point, subdivision 2B.
Mr. Else, is it also in the Senate version? You probably know the
Yes.
House better, but
Yes,
it's,
it is. I'm just using one to reference, and so I can, but this eligibility determination is in both versions, but it's in different places. So, so I can refer to one document. I'll refer to the House version in subdivision 2B. There is an eligibility determination that is done either through existing records with the VA or a professional evaluation by a psychologist, in which the defendant must show the court that they have a service-related condition and that the offense they committed stems from that service-related condition. So there has to be what we call a nexus between the crime and the service-related condition. This means that crimes where, like sex offenses, where it's really hard to imagine how having post-traumatic stress leads to a sex offense. That's why those were excluded. And it's on the veteran to show that there is the service-related condition and that it's connected to the crime.
thank you very much, Mr. Else. One of the differences between the House language and the Senate language, and by the way, testifiers, it's very important, if some of this language appears in both the House and the Senate, it's helpful for us to have you let us know so that we know we're on relatively the same page. There's one difference in regards to records, and Senator Lang in particular, I think the Senate version was a little more comprehensive as to the records available to the court. And I don't know if you've taken a look at that, but it is something that was felt by our folks here that are veterans, that having complete accessibility to all records of a veteran before the court in this situation would be important. The House version had a little more limited access to records. I'm saying that generally, and the House had a little bit more comprehensive. And I'm going to ask Senator Lang to comment on the records area and the difference between the House and Senate, and to just maybe go off in a little different area right now, and one of the differences between the House and Senate having to do with records. Senator Lang?
Thank you, Madam Chair. I guess just jumping back in here, I would assume that the language that we did talk about, myself and Representative Feist and Representative Eklund, the language that was in the Senate version, I was more comfortable with. It was a little more, let's see, it's paragraph B, actually, 149.5 on page R14, that if I remember right, it actually replaced the paragraph B for the most part, and through Ms. White, we were able to craft a little more, not necessarily restrictive, but more along the lines of having the courts be able to really look into what this individual's background was, where they came from, having a little more availability of the courts to be able to determine whether or not the individual was definitely eligible, whether the individual was.
So, Mr. Lang, Senator Lang, sorry, I think you're referring to the side-by-side language on page R14?
That's correct.
That B, and it was a two-paragraph B, and then the House language on that. Do you happen to have it marked down where that was?
I believe it was paragraph B as well, Madam Chair.
Yeah. I think
Madam Chair, that would have been 181.9. This is Representative Nelson.
I have no idea who's speaking right now.
This is Representative Nelson.
Oh, thank you, Representative Nelson.
I believe what you're looking for is on the House version is 181.9. on the side-by-side that Mr. Bjorn, or Mr. Bjorn
Right.
provided today, they've got them lined up better.
Thank you. Thank you. That's page R9 in the House language, starting on line 181.9, and then the Senate language starts on page R14. One starts on 149.5, both those paragraphs.
That is correct, Madam Chair.
And Madam Chair, this is Representative Nelson again. On the side-by-side text that was sent out by
Yes.
Mr. Bjorn this morning in the agenda, lines them up better than it is in the original side-by-side. And you can see that those two are right next to each other if you look at the side-by-side from this morning. And I don't know if you got them printed out or not, but they're online that way.
Yes, thank you very much, Representative Nelson. I do have that. The challenge is sometimes the records language is in a different area and doesn't really line up. So we have the House, but on page 2 is where 181.20 and then 149.5. Yeah, they're much closer. Yes, they are, Representative Nelson. They don't match up exactly, but they're much closer. And by the way, thank you to staff who put this together so we can at least more closely see them. Although somewhat I'd gotten used to my side-by-side flipping around back and forth to some degree, but this is very helpful. Senator Lang, did you want to direct anything more towards what the differences were?
Generally speaking, Madam Chair, the Senate language is probably a little more, I would say, invasive in a good way. It allows the court to just look deeper into the proposed applicant's background. So that was my reasoning behind that.
All right. I just wanted to take the opportunity while we were here today to highlight that particular area. I don't think it's a big difference or a point of contention, but I don't know. And so on the differences of those two records, Mr. Else or Mr. Ward, do you have a comment in regards to those differences on the record area? Mr. Else, you look like you're ready to comment.
I'm able to comment. I think either is great. I think the more records that the court has at its disposal are great. I also know that Senator Lang had some Rule 25 language that I'm not seeing on the side-by-side, at least in my quick review of it here, that would provide substance abuse evaluation records. I think that would be great. That was a very valuable contribution by him. So I think that the more records the court has at its disposal, the better.
Senator Lang, do you have a spot where that Rule 25, I think it was Rule 25, and then also something different in the Senate was requiring the working together of the Minnesota and federal VAs for additional resources should they be needed?
That's correct, Madam Chair. I'm going to have to dig for it here. My working copy is up in my office.
Can you speak right into your microphone, make sure it's on? Thank you.
I apologize, Madam Chair. My working copy is in my office. I didn't know we were going to go through this today, but there is some language that came from Joan White. I'm actually searching through my email right now, trying to find I guess I don't have a good answer right now as I'm going through here. There's also along like Mr. Else said, there is a section. Oh, I'm sorry. So there's a line 149.19 in the side-by-sides talks about the Rule 25, page R7. So that was the language I believe that Mr. Else was referring to. And then the only other change that was discussed between myself and the House Chair, and I'm having trouble finding that as well, was a paragraph number 6, I believe, that talked about
The Rule 25, Senator Lang, is on the new side-by-side. We love having the new side-by-side, but I haven't gone from what I have all marked up.
Myself either.
Yes, to this one, which is all clean and doesn't have any underlinings or stars or anything. But I did come across, thank you to Senator Howe, that on the new side-by-side on page R7, the Rule 25 language is on 149.20. Again,
Madam Chair, this is Representative Nelson. Yes, that's what I see also.
okay. I just wanted to bring some attention to some of those things that I think the Senate can actually make a contribution to an overall possible bill result by putting our minds together here and considering these things. Senator,
Madam
Representative
Chair,
Nelson, yes?
Mr. Else is raising his hand.
Thank you for helping with that. Mr. Else.
Thank you, Madam Chair. I have the copy of the, I believe you'd call it a delete all amendment that Senator
It's
Lang.
not a delete all, it's just a newly laid out side by side. It's not a delete all.
No, I'm speaking of the copy that I believe Senator Lang was saying he didn't have with him. And that has the language in paragraph I of subdivision 2 of the VA and the state and federal VA's coordination that you were referring to.
Thank you,
I
Ms.
think, which is very helpful.
Yeah, thank you, Mr. Else. The challenge, though, is that all the committee members here are we're trying to work off a common document. And so if you can find it on the, are you okay, Senator Lang? Do you have-
No, absolutely, Madam Chair. He's correct. So what we're trying to do is work off two different copies of the same
Yes,
language.
I'm
But
trying to direct us to working off of one, so everybody kind of tries to, at any rate, stay on the same page as much as we can in what we're doing here. I do have on the R15 on the side-by-side 150.17. And that is on actually page 3 of the R3 of the new side-by-side, I will call it. It's 150.3, and it's down on line 150.18, which says, including but not limited to programs operated by the United States Department of Defense or Veterans Affairs. If an appropriate treatment provider is not available in the offender's county of residence or public funding is not available, the Minnesota Department of Veterans Affairs shall coordinate with the United States Department of Veterans Affairs to locate an appropriate treatment program and sources to fund the cost of the offender's participation in the program. And so it's just a bit more language than what the House had, about 5 lines, and what the Senate has here is closer to 10, because it just goes into in case that county doesn't have it. So that's where you will find it, though, is on R3 of the new side-by-side. In the House, the language is 182.13 to 182.17, and the Senate is 150.13 down to 150.22. And by the way, members, sometimes when we repeat these things and testifiers and as well, we state this for the audio record because it is really, really helpful to listeners and also to future, just having things be as specific as we can. There's a reason for it. So members, that is what we have before us today. Do any other members have questions or do any other members have questions in regards to the Veterans Restorative Justice that is in front of us at this time? I'm not seeing any hands at this time. I see a Mr. Ben Johnson. Mr. Johnson, you're not, oh, there you are. Mr. Johnson, did you want to ask a question or make a comment?
Chair Kiffmeyer, thank you. Ben Johnson, Legislative Director for the State Department of Veterans Affairs.
Okay.
I just wanted to note on this item that was just discussed, there is some slight concern from the agency. In prior drafting, we had worked to get the MDVA reference out of the bill because we currently don't have any veteran justice outreach coordinators. It's not a position that the agency has. So it was a slight concern. I think we can work with it if we have to, but I did want to get on the record to note that that was something that during prior sessions we worked to remove references to the agency because it's not something that we currently do. We don't actively participate in veterans treatment courts. So.
Okay, Mr. Johnson, you say you don't currently actively work with veterans treatment courts, but this is something that you would work with if you had to. I'm not quite sure I caught it all. Could you maybe repeat or clarify, Mr. Johnson?
Senator Kiffmeyer, happy to. So the agency currently works mostly with county veteran service officers, or we would work with the courts as needed to address issues with finding someone's discharge paperwork or helping courts understand the service of a veteran for purposes of securing assistance through the courts. We don't offer legal assistance. We don't typically participate in any of the existing treatment courts, and the inclusion of language directing the agency to act as I guess, a case manager in those instances where a veteran is availing themselves of this new language, but the county doesn't have access to that resource. We mostly work with county veteran service officers. So the addition of the agency back into the realm of working to coordinate appropriate treatment programs or sources of funding would be a new role for us. So
Okay.
I understand its inclusion and the agency appreciates the inclusion, but I just wanted to get that on the record.
Thank you very much. I appreciate that. Question I have for you then is if a particular county initiates or uses this kind of program, and that particular county, a county veteran services officer does not have it. I'm thinking of Roseau County or some of our very rural counties, Cook County or so on, that may not. What would be the recourse should a veteran in this treatment court need such a service? Could you answer that, Mr. Johnson? What would be the recourse for the Veteran Services Officer that might be asked to assist with this? Mr. Johnson.
Chair Kiffmeyer, thank you for the question. That has always been a concern, even without the existence of this new language. That has always been a concern of the agency, and I was part of the working group that Mr. Else has continued to reference. Access to services is always an issue. Whether or not we pass this new language, giving courts the ability to, or directing courts to find these resources, primarily we work with the federal VA, and getting access to those resources is a challenge no matter what. So I don't have an answer except to say that if a court has the ability to direct a defendant to access treatment, that the best resource for them to get that treatment would be through the federal VA. So yes, geographically, Roseau County is a great example. That would be a challenge, but that exists now regardless of what we are asking a court to do.
Okay. Thank you very much for that clarification, and thank you very much for being online today, that when we brought up the subject that we were able to have you contribute and make your comments and share your concerns. That's very valuable and very important. The intention is, of course, to get a veteran as much service as possible and from as many sources as possible, not be limited by just that particular county. So that's the goal. We'll continue to work on that. Thank you, Mr. Johnson. Members, I don't have any other, and I don't see any other hands raised at this time. So I want to thank all of you for being part of this today. It was very important to have you here. There's a lot of information for us to digest and to consider. And I think the most important thing as we go forward, we all have the needs of our veterans at heart, and we'll do our best by them and consider all the comments that you have taken the time to make today and all the efforts that you have made. Thank you very much. With that, members, we do have some other testifiers who requested to speak, but it is a different issue than restorative justice for our veterans, okay? So those of you who are here or are here particularly for that, I don't anticipate any more discussion in regards to that, but you're certainly welcome to stay on and listen as we go forward. But I'm going to switch at this time to, we have two testifiers who wanted to speak to the issue that's important to them. And so I have Mr. Toll and Ms. Kranz. And so, Mr. Toll, if you'd like to go first and state your name for the audio record, and then go ahead and present your testimony.
Thank you, Madam Chair. My name is Sean Toll. I am the publisher of Minnesota political magazine, digital political magazine, Checks and Balances. And I am interested in testifying about the Senate position on banning ranked choice voting. So I will address that. Ranked choice voting is the Minnesota big lie. My written comments are far longer and include valuable information I'd like you to consider, but mainly I'm here to convince you two things: the system of voting is not what it claims to be and is not more beneficial to the voters. I will encourage you to ask me questions so I can further highlight the failures of this system. Ranked choice voting is a system that should not exist at all. And this conference committee, your predecessors, and the respective legislative bodies, State Government Finance and Policy and Elections Committee, should have prevented this social experiment from ever taking place. When the first referendum was proposed, these committees should have weighed in and stipulated election law should never be allowed to be changed or allowed at the local level, especially where local election officials can set their own rules for their own elections. This is like having the fox guard the hen house. When the matter went before the state Supreme Court, Minneapolis claimed IRV reduces the inconvenience and cost to voters, candidates, taxpayers, will increase voter turnout, encourages less divisive campaigns as candidates seek support for second and subsequent choice votes, and all are untrue. And I'll explain why, and I explain why in my written statement. But also, Fair Vote Minnesota made these false claims as well. IRV promotes the election of candidates with majority mandates, eliminates the spoiler effect, and helps ensure more diverse representation. All blatant lies. Because I'm short on time, I'll just read to you something from a distinguished Minnesotan, the great Minnesotan, Walter Mondale, wrote the following op-ed in the Duluth News Tribune in 2015 regarding the Duluth referendum. I hope Duluth voters reject the efforts to change their city's charter. Please vote no on ranked choice voting, on the ranked choice voting amendment. Voting in America should be plain and simple. Ranked choice voting is neither. It's confusing and complex. Academic study after academic study shows that while affluent and well-educated voters do well with ranked choice voting, it often disadvantages others, particularly older voters. If you think our American voting system should be transparent for all, then vote no on ranked choice voting. Mayor Don Ness said that when he first ran with 11 opponents, a ranked choice voting format would not have allowed a real debate to take place about Duluth's future. He's absolutely right. In 2013, in the Minneapolis city election, 20% of the voters who came out and voted did not get their vote counted in the final round of the counting in the mayor's race. That's a very definition of disenfranchisement. Supporters of ranked choice voting say this system guarantees a majority winner, but there's no majority winner under ranked choice voting in the Minneapolis mayor's race, and there was no majority winner in the two city council races. Ranked choice voting will not bring us more democracy. It favors the elites who know how to work the new and complex system. And finally, should know that nearly a third of the cities that have adopted ranked choice voting have repealed it. Duluvians have always been a common sense people. I hope you'll demonstrate the same common sense on Tuesday and vote no on ranked choice voting. Walter F. Mondale, Minneapolis. I think I'm at about the balance of my time, Madam Chair, so I'd like to thank the members of the committee for this time and the significant attention to this significant matter.
Thank you, Mr. Tolles. And it sounds like from what you had said, you have a written submission for the conference committee to consider. Is that
Yes,
correct?
ma'am. That is correct, ma'am.
Okay. And that has been posted.
Thank you.
Thank you, Mr. Toll. Our next testifier is Ms. Kathy Kranz. Please state your name for the audio record and then proceed with your testimony. And Representative Mason, I see your hand. I'll call on you after Ms. Kranz has completed her testimony. Ms. Kranz, please go ahead.
My name is Kathy Kranz, and I am a current Bloomington resident. Madam Chair and members, I appreciate the opportunity to address the proposed ban on ranked choice voting provision of this bill. As a constituent, I would like to address 3 things for you to think about. Fair Vote Minnesota likes to tell us that RCV has been ruled constitutional in a court challenge by Minnesota Voters Alliance. Not true. You are not told that the court case she refers to never opined on the constitutionality of RCV itself, IRV at the time, but merely that the particular facial challenge of Minnesota Voters Alliance was not sufficient to win the case. Fair Vote is not entirely forthright when they say RCV is popular and widely accepted. If it was, Bloomington is an exception that they include in their assumption. Last year, RCV passed by mere 96 votes, hardly a ringing endorsement. Secondly, I am concerned that also both Minnetonka and Bloomington RCV referendums pushed by both councils provided no program planning, rules, or procedure established prior to voting. City voters voted on a concept. The strategy of forming alliances, which I call very clearly outright election collusion and manipulation of the unsuspecting voter outcomes, only encourages the straw dogs, or referenced as spoiler candidates by Fair Vote, to influence the election. How is this enhancing our current election system for the positive? Finally, I am confused as a resident who watched her local city officials campaign to the residents for a new way to elect themselves, how Article 7, Section 3 of our state constitution does not apply to and protect municipal city elections overall. Paraphrase, you as a state legislative body may pass this ban on RCV for all local governments in the state, staying true to our Constitution and not feel bad about doing so. I want my one vote to matter and not be part of a second choice collusive strategy game between groups and special interests, and I hope you do too. I appreciate the time, and I did submit a written testimony as well.
Thank you very much, Ms. Kranz. Thank you for the time to be here today. We do have Representative Mason and then Representative Greenman. Representative Mason.
Thank you, Madam Chair. I do have a couple of questions, and I did read the statement that Mr. Toll had sent. And I'm from reading what reading that, one of my questions is it possible that each city could have a different way of counting the votes? Because normally, I guess most of us have a perception of how it's going to go, but that's not what I'm gathering from his document.
Thank you, Representative Mason. Mr. Toll.
Thank you, Madam Chair. Representative Mason, as you and I have spoke before, there in St. Paul, where I reside, we have 6 votes. In Minneapolis, they have 3. By my understanding, in Bloomington and Minnetonka, they're proposing 6. So basically, the system can be jury-rigged in any of these cities because it's the municipal people that are setting up their own system, and they're enabling themselves to. I'll even say you could have an incumbency protection component to this. You could have a situation where you would say they just passed it by referendum in Alaska. They're using it in a primary, and in the primary they're doing RCV, and then the 4 candidates that result out of that are then placed on the ballot. So it's up in the air. It's kind of like what Senator Howe said earlier about the veterans issues. It's all over the map, and it can be. And I think if at minimum the legislature should weigh in and establish what these rules should be. But I think the best way to deal with that is get rid of the system altogether.
Thank you, Mr. Tolles. Representative
Can I
Mason,
ask-
did you have a follow-up? Go ahead.
I do. I have two questions. What would happen if I put Jane Doe in space 1 and she was not one of the winners? What would happen to my vote after that?
You're asking Mr. Toll.
Mr. Toll.
Mr. Toll, I
Actually,
think,
yeah,
yes.
I mean, if the other person would like to answer, that's fine. I'm just trying to gather some more information as I'm trying to understand
I have an
RCD.
answer, Madam Chair.
Okay, Mr. Toll.
Representative Mason, members of the committee, in that case, in Minneapolis, your vote is called exhausted if you are not if you have not selected one of the final two finishers. That has happened as much as 25% of the time. So a quarter of the electorate's vote does not count in the end. It is thrown out. It's thrown away. In St. Paul, it's referred to as unassigned, I think. Let me see. Yeah, it's another term, but it's called inactive, excuse me. So the point of the matter is when you have a system that is going to disenfranchise a group structurally because you weren't smart enough to pick who the final two candidates are going to be, that is a flawed system. And I can't see how any elected official can support this. And I've tried to reach out to everybody on this committee, including Representative Greenman, including Representative Nash. I've tried to talk to everybody about this because you've all been lied to and you think that the system's good and it's not.
Thank you, Mr. Toll. Speaking of that, next will Representative Mason. I'll move on to Representative Greenman, or did you have another question?
Well, I guess the other question I was going to say is if I put Jane Doe, and we'll use the 6 where you have the opportunity for 6 spaces. If I put Jane Doe on all 6 spaces, what would happen, again, if she didn't, if she was not one of the finalists, would that name still be applicable as they're going forward? Is that, am I clear on that question?
I understand the question.
Mr. Toll, go ahead and respond.
Madam Chair, Representative Mason, when you're not using the system as they say, okay, when you put the person's name on there 6 times, but what it is the voting machines that we have do not kick that ballot out. You didn't make a mistake. You just voted for the same person 6 times. But again, if that Jane Doe candidate is not one of the final 2 people, your vote will not count in the final result.
Okay.
Representative
thank you.
Mason?
No, I think I'm understanding, so thank you very much.
Okay. Thank you very much. Representative Greenman?
Thank you, Madam Chair. And I'm just wondering, because I'm unfamiliar with both Ms. Krantz or Mr. Toll, but are either of you elections administrators in any of the cities that, or involved in the election administration in these cities that have ranked choice voting?
I am not.
Mr. Toll and Ms. Krantz. Ms. Krantz has said no. Mr. Toll?
Madam Chair, Representative Greenman, I am not. I am what you would consider a journalist, I guess. And I have observed the counting process many times, but I have never participated in it as an active counter.
Representative Greenman?
Thank you, Madam Chair. The reason I ask that is I think we're getting into a really, and I would actually love to know more, getting into some technical ways that cities run their elections. And I think we should make sure that those conversations are involved in the people who both administer those laws and the elections. The one thing I wanted to ask and say, though, because I didn't realize we were going to be taking testimony about this, is what we're really talking about here, the Senate provision is just relates to ranked choice voting at the local level. And what we're talking about is the ability of local voters to decide how to administer these elections. I believe, and you should correct me if I'm wrong, that all the cities that have passed ranked choice voting have done it on the ballot with voters. And so what we're talking about here is reaching into the decision of local elections, deciding, local voters deciding their own elections. This doesn't impact the state elections at all, just for instance, Minneapolis, and the state preempting their ability to conduct their elections the way that local voters have already decided. So I just wanted to make sure we're clear, because there's a lot of conversations on all sides of this, and I know that people really feel passionately about it. And so I hope when we're having this conversation, we are really both including all those voices, and then also really getting to that local voters in the cities that we're talking about really should be at the front of those conversations, because that's what we're talking about, is those local elections. Thank you, Madam Chair.
Thank you, Representative Greenman. I will point out, though, that yesterday when we adopted some same and similar, one of the things we did was say that special elections, or I can't remember the exact spot, should comply with election laws and Minnesota statutes as far as practicable, I believe it was. And so I think you have to realize, though, that we do have state election law for a reason, so that we work on the equal treatment of voters in regards to things as well. But at any rate, thank you, Representative Greenman. I will go to Mr. Toll, and then I'll go to Representative Nash, and then Senator Curran. So Mr. Toll, did you want to weigh in on this at this time?
Yes, Madam Chair, and I'll direct this part of it to the question you were asking, Representative Greenman. I have spoken with local elected officials or local administrators about this, and I would encourage you to do so as well. One of mine I would recommend would be David Triplett with Ramsey County. He can explain it very, very clearly. But also, just as a backdrop on this, when you have a different voting system, and we just had an election that was the cleanest election we've ever seen. And we've heard from the Republican side that they don't trust that Joe Biden was elected president, okay? So now if you have a complex system like this, where a quarter of the votes can be thrown away, do you think that's gonna really build faith in the system with people? It's not. You're gonna have more situations where people are just not gonna trust the value of their government and the value of their vote. And now some may even argue that the problems in Minneapolis were caused by ranked choice voting. So the city council that is inadequately serving its citizens over there is doing something very, very, that alienates basically a lot of people.
Thank you, Mr. Toll.
Madam Chair.
I want to, Representative Greenman, yes. And by the way, Representative Greenman, when we're discussing policy, you can have variations. Election administrators usually, follow what they are doing, but it's a good question. Thank you. Representative Greenman.
Thank you, Madam Chair. And I just wanted to, because I think my name was referenced. I believe that I'm the only, and I might be wrong, person on this, in this hearing that is a Minneapolis voter. So I would appreciate, Mr. Toll, if you talk about sort of what's happening in our city, and that we're actually talking to the folks in our city and the folks administering elections. And I'd say that not just for Minneapolis, you brought up Minneapolis, but for all of our cities and townships and counties. We really do need to ensure that we are rooting our conversations in the experiences and the folks that are in those places.
Thank you, Representative Greenman. I'll go next to Representative Nash and then Senator Curran. Representative Nash.
Thank you, Madam Chair. Just wanted to set the record straight. I believe Mr. Toll may have gotten a little bit out over his skis in assigning me as a supporter of ranked choice voting. I am not a supporter of ranked choice voting. In his rather heated soliloquy, he made it sound as if I was. Just wanted to make sure that he knew that I was not. Thank you so much.
Counting on it.
Thank you, Representative Nash. Mr. Toll, I'm going to go to Senator Curran, and then I'll come to you. Senator Curran.
Thank you, Madam Chair. And I think one of the common themes in this particular debate has always been about local control. I think the state should direct and dictate the election policies. We also heard about the trust in elections, and I would clarify, in the last 4 years, over 60% of all Minnesotans didn't trust the election results, either nationally or some locally. And so we need to make sure everybody is trusted. When Mr. Toll talked about the exhausted votes, that your vote doesn't matter and it's discounted, those are all valid, legitimate activities. If you don't know who your vote went to, the winner or loser. You don't know how that process works. It's so complicated. And I think one of the things that's really shown us is that many get into the race to participate, not necessarily to run. So it really dilutes the ability to thoroughly vet a group of key candidates who are interested in actually winning. It gets even worse when you have at will or multiple candidates for an open seat, where the counting gets even more complicated, and it just is too, it's unnecessary. But the other part that's a common theme about local control is all of these initiatives where they are don't appear to be driven organically through local initiatives. It's all a national effort through Fair Vote and a variety of organizations who want to come in and influence our elections. And frankly, they have no home here, and we should be dictating what the local policies are so it's consistent throughout the state. So that's, of course, why I'm the chief sponsor of that bill. And I know, Madam Chair, we agree that that election process should be eliminated in the state of Minnesota. Thank you.
Thank you, Senator Coran. As one who's done a great deal of voter education, I assure you, even one person, one vote, and the process that we have today takes a lot of educating, and I'm very sympathetic to this ranked choice voting and it increasing complexities and questions and concerns, and especially disadvantaging those who may not be as knowledgeable about the process and how to do it. And I participated in several of them, and I started getting the hang of how I could structure, everybody thinks, take your first choice, so on and so forth. I started figuring out, no, don't put my first choice first, put my first choice third, so I have a chance at not being knocked off in the first round. And there, I look at something like that and I'm saying, but doing a voter education, one person, one vote, and those who are actually campaigning for a particular office, I'm very sympathetic to that as well, Senator Coran. And so, members, I don't have any other hands at this time. And
Madam Chair.
Mr. Toll, sorry, Mr. Toll.
No problem.
Senator Carlson has raised his hand. Mr. Toll, you can have one last opportunity to make a comment at this time, and then I'll go to Senator Carlson, unless you want to wait.
I wanted to clarify, Representative Nash, I did not want to imply that you were a supporter of ranked choice voting, but I did want to talk to you, and I referenced the fact that I reached out to you, and that's what I was saying. But in addition, Representative Greenman, in regards to this system, okay, you asked a question about if it's been passed by the voters and things. In the city of St. Louis Park, they actually did not have a referendum. It was passed unanimously by the city council. And then they moved it in, they advanced it into their charter. And then they had the election, which they didn't tell the voters what, they just asked about having a voting system. This is what Ms. Kranz referenced. They talk about the system, but they didn't lay it out. They didn't lay out the specifics. And after that election was over, then they set their own rules for their own selection process. To me, that doesn't seem very, very wise, that you can basically have somebody be able to decide how they are going to be selected, and there's no public input at all, other than somebody maybe testifying in a hearing before the city council.
Thank you, Mr. Toll. With that, I'll go to Senator Carlson.
Thank you, Madam Chair. I guess I have a couple of thoughts here. The first one is that this was a bit of a surprise to cover this today. We were not given very much warning on it. And in fact, we're not really having a back and forth conversation because the proponents of ranked choice voting were not invited to testify. And I've got that in a text while this discussion has happened. And we've given some credit to people who are using terminology, the lies, all that sort of thing. And I think what we need to do is we need to have somebody that really knows what this is all about. Plus, we can refer to the Supreme Court decision that this is certainly constitutional, and it is a much different system than they had in Duluth, and in fact, the Supreme Court did not support that system. Vice President Mondale was writing about that system, not about what we're talking about here. And also, here we are sitting and talking about preempting what the local individuals have voted for and what their leadership has. And in fact, if they want to get rid of it, they certainly are free to do so. But we're preempting their decision, the decision of local elected people or local electors to vote for the system that they want. And I think that that deserves a lot more conversation before we just throw it overboard with a one-sided conversation. Thank you, Madam Chair.
Thank you, Senator Carlson. Senator Carlson, I'll say that when people request and reach out to us and they want to testify and had not yet been able to do so, we followed through with that. We had time on our agenda today to add something, and we also had names, and we posted them as soon as we had their names so that you would know who was going to be testifying today. And so you're welcome. If somebody has not testified in some other way, they are certainly welcome to do so as well.
Madam Chair.
And also, we can continue it, yes, on another day. Mr. Toll.
Madam Chair, thank you. Senator Carlson, you were incorrect on your assumption that Walter Mondale was talking about the other issue. That was referred to in the court case in 2009. So that issue was actually settled before, and it's actually in the court record. But I actually was in personal conversation with Vice President Mondale about this very issue, and he had provided me a different quote, but I took the one from the Duluth News Tribune because it was actually the referendum was whether you wanted to adopt a ranked choice voting system, and it failed 75-25 in 2015.
Thank you, Mr. Toll. As you can tell, members, this has a lot of strong thoughts on both sides of that. We recognize that. And because of the situation, Senator Carlson, I'll give you a chance to make a comment here.
Yes, I would like to. And I do want to say that you did refer to Duluth. Mr. Towle did refer to Duluth, Madam Chair, and he has it in his own testimony here, and written testimony. And at this point, we've given Mr. Towle several chances to give his opinion, and we haven't given anyone on the other side any time to refute his assumptions. So thank you, Madam Chair.
Senator Carlson, those members are welcome to come before and make the request of this committee just as those have done so today. So thank you very much, Senator Carlson. If you have friends and members who are supporting ranked choice voting, they are welcome to make the same request as has been announced previously. Anybody can come and testify to any part of this bill that we have here today. We've had some folks today who have previously testified, and we gave them the opportunity to testify again today. So some matters just take a little bit more of that, and so that has been how we've handled it today. So thank you very much, Senator Carlson. We'll look forward to an ongoing discussion with that, and I would very much enjoy hearing from them. Members, with that, these are the testifiers that I have before us today. I don't have any other actionable items. Chair Nelson, would you like to make a final comment or announcements or anything, just an opportunity, because you have the gavel tomorrow.
Thank you, Madam Chair. And members, tomorrow, one of the other outstanding pieces in our bill is the policy or the pharmacy benefit management or manager piece, the reverse auction language. There's been multiple people, and I know this came late in session and got put into the bill, actually put in both of our bills, and there's been some discussions continuing on this to try and make it a better bill than what we passed. And so tomorrow we'll be having discussions on that. And again, if anybody wants to testify on another issue, feel free to sign up, but tomorrow we're going to try and spend the time, like we did today, hashing out and digging deeply into the policy or the pharmacy benefit management section of this bill. Madam Chair.
Thank you, Chair Nelson. Members, some of you may have heard about this pharmacy benefit management as was a bill that we have heard previously and actually did some new licensing and a variety of reforms in regards to that area. But this particular one is about the reverse auction. That is a new proposal in regards to the state employee insurance program and others languages as well. So it's about the reverse auction having to do with pharmacy benefits. Representative Nelson, you're leaning forward. Did you have another comment?
I was going to say that's correct, Madam Chair. It's about the reverse auction piece of doing that.
Right.
So that's what we're going to be discussing tomorrow.
Fantastic. I appreciate that very much, Representative Nelson, and also to others who wish to testify about any portion of these bills. Sometimes we're able to coordinate them. Other times they come forward as they come forward, and then we will have a discussion and continue on with it as we go here. But members, having completed our agenda for today, we will adjourn, and members, my understanding is 9 a.m. tomorrow morning, State Government Conference Committee, and this will be all Zoom. Is that correct, Representative Nelson, Chair Nelson?
That's correct, Madam Chair. Tomorrow morning, it'll be start at 9 a.m. And it'll be on Zoom, and testifiers as today will all be on Zoom. And so members, I look to see you tomorrow morning at 9 a.m.
Thank you very much. With that, members, we are adjourned.